back to another episode of 60-Second Law School. Today we're talking about making provisions in your will for your pets. Sometimes I get asked by my clients if they can leave money behind for their pets, and the simple answer to that question is yes, you can, but it's not that straightforward because in the province of Ontario, pets are considered property, like your car or your TV, and although you may love your pet like a child, pets do not have the legal capacity to own property. So you simply can't just set up a trust fund in your pet's name and leave the money for them in your will. So how do you do it? Well, before I tell you that, I need to warn you to please consult with an estate solicitor before implementing any of these strategies and seek their assistance so that everything is done properly. Don't try to do this by yourself. Without warning out of the way, here goes. The first strategy would be to leave a sum of money to a person who would also become an owner of your pet and take care of them for the rest of their life. There's two problems with this strategy. The first problem is that once the money is received by the guardian, you have no control over whether that person actually spends the money on your pet and takes care of them the way you want. Any instructions that you would leave in your will is non-binding. So in order for the strategy to work, you have to pick someone as the guardian and recipient of this money who you absolutely trust and will honor your wishes to the letter. The second problem with the strategy is that if the person dies before your pet does, that's the end of their obligations with respect to your pet. So in order for the strategy to work, the guardian would have to make provisions in their will for the ongoing care of your pet, and there's no way of guaranteeing that that's going to happen. The second strategy is to establish a trust fund to take care of your pet. Your pet would be given to someone to take care of them. They become the guardian. And another person would become a trustee of a trust fund who would be responsible for managing that money and making sure that that money gets given to the guardian and spent in the proper way and fully taking care of your pet. So you have a trustee to hold and manage the money, and you have a guardian to take care of your pet. So one person controls the money, and the guardian would actually take care of your pet. Using this strategy is useful because you can name alternate trustees to deal with the death of a trustee before the death of your pet to ensure that your pet is properly cared for until they pass away. However, there is a maximum time limit for all trusts to be in place. And if the trust is not exhausted by that time limit, the funds would have to go somewhere. And if there's nothing in the will about it, the balance of the trust fund would go back into your estate and distributed to the other beneficiaries.
Well, there's the bell, so that's all the time we have for today. Thanks for watching. See you next time on 60 Second Law School.